At first, I believed those shipping containers were temporary. The HOA told me they needed storage space for a few weeks, but when I counted them, there were 14 large units sitting on my open land. I pulled out my property deed and checked boundary lines carefully. There was no mistake. The entire storage area sat completely inside my private parcel. Yet the HOA had never asked me to sign a lease. That was when I realized this situation could become a very serious problem. Evelyn Vance, the HOA president, arrived that afternoon and claimed the containers were part of a community development project. I asked where my written permission was documented, but she simply replied that everyone lives under association rules. I reminded her that my private acreage was not subject to common area storage rules. Evelyn laughed and claimed I misunderstood association documents, threatening to fine me if I moved anything. That night, I inspected every single container and found locks, inventory tags, and seals. I realized the HOA was using my private property as a massive warehouse. Nothing in their paperwork gave them permission to occupy my land for free, so I saved all emails and photos before hiring a lawyer. My attorney studied the documents carefully before asking if they had ever paid me rent. When I shook my head, he advised documenting every delivery date, vehicle, serial number, and exact square footage. I gathered undeniable evidence before taking the next legal step. Meanwhile, Evelyn sent a formal letter claiming the containers were community property and demanded that I stop interfering with operations. I forwarded her letter straight to my attorney. 2 days later, my lawyer sent a formal demand for a property use agreement and unpaid back rent. When the HOA refused to pay, our dispute went to court. Evelyn arrived believing the judge would side with the HOA, but I brought survey maps, photographs, and property records. The courtroom grew silent as the judge examined our parcel boundaries line by line. The judge asked why the association had never obtained a valid lease, making Evelyn look genuinely worried. She argued community benefit, but the judge noted that public benefit does not create land rights. When the judge asked if Julian had ever been compensated for land usage, her attorney had no answer. My lawyer presented our timeline showing 14 containers, months of occupation, and 0 rent paid. The judge ruled that the HOA had no right to occupy private land without a lease and ordered full financial compensation. However, the court then addressed what was actually stored inside those units today. When the HOA failed to pay the ordered storage costs, the court authorized a lawful judgment remedy. The contents of the containers were treated as assets available to satisfy their unpaid financial debt. Evelyn's confident expression completely disappeared. The HOA tried to turn my private property into free warehouse space, but their unpaid obligation created unexpected legal consequences for their board. My attorney smiled and noted that keeping every receipt saved the case. Next came a supervised inventory where every container was opened and recorded, according to strict instructions issued by the court. Weeks later, all 14 containers were finally removed from my land. I replaced old boundary markers, filed court records safely, and proved ownership means nothing unless you defend it with evidence. The HOA never expected me to challenge their claim in court or lose their stored assets over unpaid rent. If you were placed in my position, would you have fought back to protect your private property rights?